Hi, I'm Stan Farmer, Director of International Financial Planning at Wagner Condon, and today I'm going to speak very briefly and generally about cross-border estate planning, and specifically what I would call the three foundational principles of international estate planning. Okay, so first let's back that up a little bit and let's just get a clear idea of what it is I mean by estate planning. Estate planning would be the formulation and implementation of a strategic plan for the transfer or eventual transfer of your wealth, okay, during and after your lifetime. Okay, so really what we're talking about is setting up a plan for how you would, wish to have your wealth shared with others, either while you're still alive or ultimately upon your death, and possibly for a generation or two thereafter. Okay, so in the international context, let's remember that as Americans, we carry our tax obligations with us to Uncle Sam no matter where we are in the world. And that's not just income taxes, that also applies to death or gift taxes, right? Estate tax and gift tax also travels with you, okay? But when you live in another country, you're also subject to, and ultimately, if you're living in another country long enough and you are a tax resident of that country, you may ultimately become subject to the gifting and probate or succession rules upon your death in your new country of residence or your domicile, okay? So first and foremost, okay, rule number one, general guide, if you will, don't assume that an estate plan that you set up in the United States when you were living here and domiciled here will travel well when you take up residency and settle in and really adopt a new country of residency, okay? The U.S. rules and the rules in other countries are very different. And generally, when we're talking about wealth, we're talking about your property, right? And property law is local. There's no such thing as international property law, or not really, right? Foundationally, the rules and the legal culture in one country may vary dramatically from another country. And this is particularly true of property law in the United States because we are using a common law legal system, and very few countries in the outside world practice that type of law. So you're setting up an estate plan in Oklahoma or Iowa or California, wherever you happen to live, is going to apply, antiquated and very old laws that have, been in existence for forever, basically, in those jurisdictions, and the formalities of a will, for example, or the types of trusts that you can create, and the exact way that you can construct a trust to have a certain effect. Okay, may have an entirely different effect, or may have no effect in your new country of residence once you leave the borders of the United States, or even really if you transfer to another state, even the rules could change, and you need to revisit your estate planning. Okay, so rule number one, revisit your estate planning certainly once you've arrived in another country, but for strategic reasons that should be clear, before would be preferable, right? So that if you need to shift your assets or restate your assets in one way or another because of these different rules, or get rid of your old estate plan and extinguish whatever trust that won't work in your new country, you do it before it becomes, an issue, right? So rule number one, don't assume that your domestic estate plan will travel well with you. It likely won't, okay? Rule number two, and this is I think if you remember nothing else from this video, rule number 2 is keep it simple, okay? You've already got this complicated dynamic of having to basically pay attention to and thread the needles through 2 different legal systems now. The U.S. system and your residence country system, okay? The simpler your estate plan is, the more basic it is, the more likely you can pull it off, okay? You can pull it off successfully. And the way that it would work in the United States will be hopefully the way that it will work in your new residence country, okay? Rule number 3 is if you don't pay attention to number 2, or you're simply, the kind of individual that has very specific estate planning goals that don't lend themselves well to keeping it simple. So if you do not keep it simple, for whatever reason, you need to be willing to pay up, okay? And I mean pay up for the very best, the most specialized legal assistance, both in the United States, meaning somebody that's not just a good estate planner in Oklahoma or Colorado or wherever you lived, or where you might still have, your vacation home or a second residence, but also pay up for, somebody that has experience dealing with international situations, okay, and has the ability to connect and coordinate with legal counsel in your residence country, okay? So you're going to need 2 legal teams essentially, most of the time. That would be your U.S. team and your residence country team. And these people need to have, on both sides, some experience and comfort and skills that lend themselves to working with people in your situation, which as an American expat is particularly unique on this planet, okay? So be willing to pay for that if it needs to be complicated. If you think that sounds unappetizing, go back to rule number 2 and keep it simple, okay? These are the type of things that generally is an important part of financial planning. It's the type of strategizing and generalized planning that we do for all of our expat clients at the international team here at Walkner Condon. So if you'd like to know more, feel free to reach out to us and have a one-on-one call with somebody on my team here at Walkner Condon. We'd be glad to help direct you in the right direction. Thanks.